Restrictive employment covenants and contractual issues. And let's see, the biggest challenge, of course, for me is to see if I can get this to work. Anyway, Maine does have a statute about non-compete agreements. We went over that last year, so that's why I call it a refresher course. You simply cannot, well, I'm going to go out of order just a tad here because the next slide, I believe, is what is a non-compete agreement. And the traditional non-compete agreement was, as it sounded, you'll say the former employee is prohibited from competing directly or indirectly in any way against the former employer for some amount of time. And it was just couched in terms of you can't compete. And sometimes they would be couched in terms of you can't do it within 50 miles of the employer's location, back when location had more, mattered more, and it still matters in some industries and businesses. Sometimes it just said you can't work for a year as an optician, for example. Usually it said you can't work as an optician or something or other within 50 miles of the employer's former location or some amount. Those are definitely non-competes covered by the agreement. Probably, and I'm beginning to think almost certainly, the old-fashioned just you can't compete directly or indirectly against the former employer for a certain amount of time. Those are non-competes within the meaning of the agreement statute. What's not a non-compete, and so where the trend is really moving now is towards so-called non-solicitation agreements. And that's where the employer identifies specific accounts or customers and says after the employee leaves for any reason, the employee cannot for a certain number of years solicit and take business from any of these particular customers or clients. And often there's a list, even depends again on the business and the industry, whether it's you can have a list or not, whether that's practical. And often they prohibit solicitation of prospective clients or customers, defined as customers that the employer is trying to get business from within a year before the employee leaves employment, for example. And also restrictions on the use of confidential proprietary information are also not non-competes within the meaning of the new statute. So if you do have a non-compete, though, and as I say, we're seeing less of those, the statute says, well, if it is a non-compete, you can't do it if the employee makes less than $51,520 a year. That's for 2021. It'll go up slightly for 2022. Furthermore, if the employee signs the non-compete, regardless, it can't take effect until the later 6 months or 1 year. And the 6 months means 6 months after the signing of the agreement, or 1 year of the employee having worked for the employer, whichever is longer. So if it's a new employee and you want me to sign a non-compete, then even if it's otherwise lawful, it's not enforceable for 1 year. So he could quit right before the end of the year and violate the non-compete, and you couldn't do anything about it. You also have to disclose the requirement before a job offer. If there's going to be a non-compete, you have to give the person at least 3 business days to consider it. I put asterisks by those 3 because for each of those, if you violate it, it's a penalty of not less than $5,000. So that's rather a lot. And I do find that probably still people forget the requirement to disclose that there's going to have to be a non-compete before the job offer, because a lot of times employers just forget about it or they don't like saying that, but it's part of the law. But again, this is only if it's a non-compete, if it's a non-solicitation or a confidentiality provision, doesn't fall within the statute. Obstacles to enforcement of non-competes, even if, and this would be to some extent even non-solicitation agreements, is there can be reputation in the community, although that cuts both ways. Some employers would want to show that they are tough on enforcing these sorts of things, and so they're quite happy to have that reputation in the community. In other situations, the employer could lose goodwill by attempting to enforce it because some possible employees who might otherwise go to work for that employer might be put off by that, and by word of mouth say, well, I don't want to work for them because look how badly they treat their former employees. Costs money to enforce these things. The facts sometimes are difficult to prove. If you win, it can be tough to collect. There are interstate complications if the employee goes to live somewhere else and is competing there. And regardless of whether or not it's a non-compete within the meaning of the statute, the law is still that judges will not enforce it if the judge deems it, quote, unreasonable in duration or territory. It's, you know, it's difficult for me to imagine a case where if it's purely a non-solicitation agreement, where there's a list of customers that are off limits to the former employee, I don't see how a judge could say that, well, that's unreasonable, you know, if frankly, for any duration, but maybe if you said 50 years or something, you know, might be deemed unreasonable. But nevertheless, lawyers can be pretty clever about coming up with various arguments, and some judges are unpredictable, and you know what is reasonable and what is not reasonable. So you never really know when you get in litigation, and so it is another potential obstacle. A different statute, which went into effect on September 19th, 2019, pertains to so-called restrictive agreements, and it's an agreement between employers that restricts one employer from hiring the other's employees or former employees. And that's simply unenforceable in Maine now, even if that agreement was entered into before September 19th, 2019. And there have been a couple of cases that have acknowledged the validity, I'll say, of this statute, even with respect to a contract entered into before September 19th, 2019. And so it's simply unenforceable. It's a little bit, you know, it sounds simple on its face. Agreement between employers that restricts one from hiring the other's employees or former employees. It's sometimes not totally clear what it means by employer, though, in certain situations, because you'll see in some business deals, I'm the sole owner of a company, and my company employs people. I don't employ them, at least certainly not directly. My company employs them. I'm selling my company. Someone else buys the assets of my company. And one of the things they want is for me to promise that I'm not going to solicit some of my former, some of the employees of the company that I used to own to come work for me in some other capacity. And so, if I sign that, am I an employer or not? And I suppose if I do sell my company and then I do try to hire one of the former employees of what used to be my company, and somebody says, well, you can't do that, that's unenforceable. I'm probably, when I'm trying to hire that other employee, my former the employee of my former company. I'm probably doing that in the capacity as an employer. So to make a long story short, as a lawyer, without any court guidance on this, I'm a little bit uncomfortable even having the owner of a company promise not to hire any of the former employees of his company. Merely entering into such a restrictive employment agreement after September 19, 2019 is unlawful. Just entering into it. And that exposes each employer who entered into it to a fine of not less than $5,000, enforceable by the Maine DOL. And enforcing or threatening to enforce such a restrictive employment agreement is also unlawful. So if there was if back in 2013, an employer signed such an agreement, and it's just sort of been sitting there on the shelf, but now that one of the signatories to the agreement is trying to hire away a former employee of the other one, the aggrieved party could could let Maine DOL know, and Maine DOL could intervene, and the employer could be looking at a fine of not less than $5,000. The other statute that I want to talk about briefly here is give a little bit of a historical context. This won't come as a surprise to any of you, I don't think, but it did surprise me a little bit. Right in the statute that was enacted this past year, it recites some of this history. And it recites that since 1965, Maine has had a statute that has provided that an employer may not discriminate between employees on the basis of sex by paying wages to any employee in any occupation at a rate less than the rate at which the employer pays an employee of the opposite sex for comparable work on jobs that have comparable requirements, yada. And in fact, I went back and I looked. In 1965, there was such a statute, and that is exactly the wording from the 1965 statute. It looks like there was a form of the statute that even predated 1965, but it's certainly been on the books in Maine since 1965. So the new statute that was just enacted, which is 54 years and probably more than 2 generations after 1965, says that the legislature has found, and this is this last year, that, quote, despite requirements regarding equal pay having been part of the laws of Maine since 1965, wage inequality is an ongoing issue in Maine. And so the legislature further found that an employer's knowledge of a prospective employee's compensation history is directly related to the practice of basing compensation decisions on compensation history. And when employers do that, that perpetuates the wage inequality. So under the new statute, the rule is, the title of the statute is Compensation History Inquiry Prohibited. And the new statute provides that until an employer has made a firm offer of employment that includes all terms of compensation, the employer, quote, may not use or inquire, so the 2 keywords there are use or inquire, about the compensation history of a prospective employee from the prospective employer or current or former employer of the prospective employee. So if I'm thinking about hiring an employee, I may not inquire about, and I may not use the compensation history of that prospective employee. I may not use it at all. Under the statute, it says I'm only prohibited from inquiring about it from the employee or from the employee's current or former employer. But I wouldn't bet too much on whether I might run afoul of this statute if I somehow went to some third party and inquired about it. And the mere fact that I'm inquiring about it presumes I want to use it for some reason, and that would definitely violate the statute. There are some issues about how would one prove a violation of the statute, which you can that. Going backwards here, there's quite a bit of under the statute, if an aggrieved employee who sues and wins is entitled to the attorney's fees, so that's an important point because that makes it more likely we'll see these cases. Any unpaid wages as sort of a penalty, twice the unpaid wages, and also a forfeiture of not less than 100 nor more than 500 for each violation. I'm going to finish my presentation here by a potential nightmare scenario, because I do some transactional work, and it's not at all uncommon for there to be an asset deal where the seller is selling the assets of the business, and say there are 500 employees, and traditionally the buyer has always required the seller to provide a list of all the employees of the seller, including exactly what they're paid. And in fact, the buyer even makes the seller promise it's an accurate list. So suppose the buyer then buys the assets and hires 425 of the 500 employees and starts them at the same compensation as their former employer. And this has happened traditionally for years and years and years. That could well be 500 violations of the statute, which could be up to a $250,000 fine because the employer inquired as to their wages. And then you could have potentially 425 plaintiffs suing for unpaid wages, compensatory damages, interest, and attorney's fees. So the better practice today for buyers is to just get bulk information from sellers about overall payroll costs, or if not, make sure the buyer can prove that the person doing the hiring never saw the seller's list of employees with their compensation histories.